So very warm welcome again to the Alumni Festival session on artificial intelligence and dispute resolution. My name is Felix Steffek, and I'm a university senior lecturer at the Faculty of Law, where I'm also a director of the Center for Corporate and Commercial Law. I'm now based at Newnham College. However, during my studies, I was based at St. John's College, where I studied law. My research interests now cover corporate law, insolvency law, commercial law, dispute resolution, and technology and law. And that will be the issue we discuss today. So I'm very much looking forward to discussing the use of artificial intelligence and dispute resolution with you. So let's get started. Artificial intelligence and dispute resolution. When I discuss artificial intelligence and dispute resolution, I mainly focus on civil and commercial dispute resolution. I'm less concerned with criminal law issues. When using the term artificial intelligence, AI, I do understand it widely in this presentation. That is, it covers machine learning, and in particular deep learning, and also natural language processing. What will I present on in these 30 minutes? First, I will introduce you to the Case Crunch Lawyer Challenge, a competition between machine and humans that took place in London. I will then explain how artificial intelligence was used in that competition to give an example of AI and how it is used in practice. I will then move on and give you an overview of existing studies on the use of AI to predict case outcomes. After that, I will discuss more use cases of AI in dispute resolution, and then end this presentation with some of the hot topics, and that is bias, transparency, and ethics. So first, the Case Crunch Lawyer Challenge. This was a competition that took place in London almost 3 years ago, in October 2017. It was organized by students of this university, and they had written an AI, and they invited lawyers to compete with that AI in predicting the outcome of cases. The cases that everyone had to predict were real cases, original cases taken from the Financial Ombudsman Service. And the Financial Ombudsman Service had been very kind and provided real cases that had been decided in the past. These were cases on payment protection insurance. Payment protection insurance is an insurance product that enables consumers to ensure the repayment of credit if the borrower, the consumer, becomes ill or disabled, loses a job, or faces other circumstances, preventing them from earning income to service the debt. Now, PPI, payment protection insurance, was widely sold by banks and other credit providers as an add-on to loans and overdraft products. However, consumers then often felt that they did not really need this insurance or were pushed by the bank into buying it. So, what of course no one had access to, not the AI and not the more than 100 commercial lawyers participating in this competition, was the result, that is the decision of the Financial Ombudsman Service. They only got the facts. And so the more than 100 commercial lawyers predicted more than 750 cases. And the prediction was essentially whether the consumer would win or not. The AI did the same. And then after 1 week, this was 1 week in which the lawyers had, or the lawyers had the opportunity to make their predictions, the results were announced at a conference in London. And here, a virtual drum roll for the results. They were as follows. The top lawyers, mainly from London, achieved a prediction accuracy of 62%. That is, in 62% of the cases, the lawyers were right in predicting whether the consumer would be successful or not, bringing their case to the financial ombudsman. The AI, the case crunch technology, was successful in 87%, and that means the AI won the competition. Now, after these results were announced at the conference, there was a discussion, and the discussion then soon turned to other issues, such as costs and time. Once the AI was set up, the cost of predicting a case was a fraction of the costs of the lawyers. This is something the audience remarked in the discussion we had. And also the audience agreed that the time the AI would take to predict a case compared to the time the human lawyers would take was quite different. Again, it would be a fraction of the time the humans would take. The results were widely reported. They went around the world, and the competition was presented in the New York Law Journal, for example, but also the BBC. And I'll come back to that because in these articles, soon other issues also came to the fore. But before I do so, I would like to know your opinion, or actually what you would do in practice. So here is my first question to you, and you should now have the possibility in the poll to answer that question. And please tick one answer. The question is this: if you had a PPI dispute with your bank and you considered an application to the Financial Ombudsman Service, who would you rely on to estimate your success chances? You can choose between a human lawyer, the case crunch technology, or the human lawyer using the case crunch AI. I think there's a pretty clear result here. The most members of the audience, 68%, would ask a human lawyer using the case crunch AI. And then 25% would only use case crunch, and 7% only would go to the human lawyer. So it seems that you are trusting the AI to produce better results. And those opting for the case crunch AI operated by a human lawyer may have chosen that option either because they prefer the human lawyer to operate the case crunch AI, or because they would still have and prefer a human voice explaining things, or perhaps even adding an evaluation. Now, how was the AI actually applied in this case? What the students did is they first got a data set, and that was 100,000 cases from the financial ombudsman. Now, 10% of those cases were taken away to form the data set that would be the training data set. So you can imagine this to be a data set. Imagine it like perhaps an Excel spreadsheet where you've got one column that is the case ID, a second column you've got all the facts together in one cell, and then for each case a third column where you've got the result. Now, what is important for the data set in that case, the training data set, is to tell the AI whether the consumer was successful or not. And already at this stage, the students used natural language processing to establish whether the AI was successful or not. And an example of how that was done is that an algorithm determined that if the word unsuccessful was found in the last sentence of the decision part, then a case was classified, for example, as consumer loses. And so you then, by doing this, you'd get another column in your virtual Excel spreadsheet where you have the information whether the consumer won or not. Now, this was done for 10% of the 100,000 cases. That means 10,000 cases. And then a neural network was employed to teach itself by trial and error, comparing the facts only and the outcome defined, as I've just explained, establishing which factors in the cases would determine the outcome. And that is the AI at work teaching itself what the relevant factors are. On the slide, you see an abstract representation of this neural network. And what it shows is that there are many factors, and it is not a linear way of arguing or establishing reasons why the consumer would be successful or not successful, but rather a multiplicity of factors. And even for those operating the AI, it may not always be clear what factors the AI finally trained then uses to establish the outcome. However, in this case, as shown, the AI ultimately reached a prediction accuracy of 87%. The effect that even those establishing the AI do not always understand what the relevant factors are that the AI uses to establish the outcome is what is sometimes called the black box effect. And I'll come back to that later in the presentation. Before I do so, I would like to present some more recent research on using AI to predict the outcome of dispute resolution. So here you see on this slide, you see some selected studies only from the recent years, starting in 2017, where researchers have used AI to predict the outcome of dispute resolution cases. You see in terms of dispute bodies, a representation here in these studies of the US Supreme Court, the French Supreme Court, Chinese civil law courts, the UK Financial Ombudsman Service, that was the case crunch competition I've just introduced, and the European Court of Human Rights. Now, if you move on to the next column, you see the basis, and that is the information the researchers gave to the AI to establish and predict the outcome. Now, in the 2017 study by Katz and others, only meta factors were used. That is, the only thing the AI got was meta factors such as circuit of origin of the case, the issue area of the case, for example, criminal law or employment law, the type of the petitioner, for example, whether an employer or the United States were the petitioner, the type of the respondent, and whether the petitioner argued that law or practice was unconstitutional. In that case, the data set used had 28,000 cases, and a 70% outcome precision was reached. In the French Supreme Court project, there were more decisions in the data set, 126,000. And in that case, the AI only got the facts. So what is noteworthy here is that the AI did not get any information on the law, and it still reached an outcome precision of 96%. In the project on Chinese civil law courts, the AI also got some information on the law and the applications, that is the submissions of the petitioners. Again, a pretty large data set of 100,000 cases, and a precision of 80% was reached. Then you've got the case crunch technology, which I published on together with Ludwig Bull, where the AI, again, only had access to the facts, 100,000 cases strong data set, and an 87% outcome precision. And finally, a study on cases concerning the European Court of Human Rights. Here, the data set was smaller, only 11,500 cases. But again, the AI, what I report on here, used only the facts and then reached a precision of 90% outcome precision. So this is essentially a short overview of the state of research on using AI to predict outcome of dispute resolution. Now again, back to you and the next poll. The next question I have for you, and again, I'd be grateful if you would tick one answer, is your opinion on the following statement. The statement is this: it would be good if citizens and businesses had access to AI services predicting the outcome of dispute resolution procedures, such as court litigation, arbitration, and ombud schemes. So would the world be a better place if citizens and businesses had access to such applications? Right, so again, a pretty clear outcome. So it seems that the audience is pro AI because altogether, almost 90% either strongly agree or somewhat agree with that statement. So it seems that the clear majority in the audience thinks that the world would be a better place if people could actually use AI to predict dispute outcomes. Now, you see here the BBC website reporting on the case crunch competition, and I think already the heading shows that it's not just precision, costs, and time. There's more at stake. Because the heading says, the robot lawyers are here and they are winning. So it seems there is a competition beyond the competition going on, or at least it is perceived to be one. And that is the question for the role of the humans in dispute resolution. The question, what is good dispute resolution? So in order to answer these questions, I would first like to explain more use cases of AI in dispute resolution, and then discuss some of the underlying challenges and problems of using AI in dispute resolution, that is bias, transparency issues, and ethical questions at the end. So first, use cases. So this kind of widens our perspective in terms of what AI can actually be used for in dispute resolution. And I think the three topics are information, analysis, and decision. And you see that on the one hand side, judges, arbitrators, ombudspersons, in short, decision makers can use AI. But also you see the party side. And with this, I'd like to emphasize that it's not just those deciding on disputes who might be interested in using AI, but also parties. And that is interesting because if parties can use AI in their interest to improve their way of dealing with disputes, it means that we might see AI influencing dispute resolution, even if the state side, the organized institutions, do not use it. So what are possible use cases? First, AI might be used to improve information. That may concern database research, information extraction, or finding relevant laws and cases. To give you an example, a judge could use AI to extract relevant evidence from submitted documents. So instead of reading everything, the judge may use AI to find the relevant issues in the many documents submitted. A party may instead use AI to identify the relevant case law in order to be better prepared for going to court. Then analysis may be improved by using AI. You've seen one example in terms of the case crunch prediction, and that concerned predicting the outcome. But one may also use AI to predict the time a court case might take, or to predict the costs that may be incurred by going to court. Then AI may be used to find the relevant factors, that is kind of to reverse engineer and find out which factors were relevant for decisions in the past. Or AI may be used to value claims. So for example, if a party has a claim against another party, an AI can help to put a value on that claim, then it might be easier to sell that claim in case the party does not want to go to court, but rather prefers to liquidate the claim and let someone else deal with it. And then governance may benefit. For example, if courts can analyze past decisions and find out whether they are consistent, find out whether there is perhaps discrimination in those past decisions, then courts could improve their governance to avoid such problems in the future. Examples are from the party side, to get more information on the time and the money that needs to be spent to go to court, in addition to predicting the outcome. And for courts, it may be an opportunity to understand whether past decisions were correct, and if not, then learn from mistakes. And then the third bigger issue in terms of how AI may be used in dispute resolution is to improve the decision-making process itself. So to help to directly give information on which action to take, or even to help drafting documents, or in the most extreme case, to automate resolution. Again, to give some examples from the court side, someone might say it is perhaps helpful to have an AI check decisions that have already been drafted, or even to provide some drafting support. For the party side, it may be helpful to ask AI for decision information on whether to bring a claim or whether not to bring a claim. Now, I think two comments are necessary here. First, my first comment is that by saying that AI may be used, I'm not saying that it should be used. So everything I've presented up to now only explains possible uses of AI. It does not mean that I'm arguing for its use. So when I say that AI may be used in the decision-making process, then this is a feasibility question and a feasibility answer. I'm not yet saying anything on whether that should actually be done or not be done. The second comment is that I think an interesting perspective on these use cases is the access to justice perspective. And that is, for example, a perspective that the OECD takes. So the OECD, looking at access to justice worldwide, estimates that 4 billion people have no access to justice, in the sense that they do not participate in the justice system because the law is too complex or the law is too expensive. And the OECD research shows that it's not just in other countries where that is the case, but it also concerns this country, where, for example, small and medium-sized enterprises or consumers struggle with understanding law, with the cost of using the law. And if one doesn't use law because it's too complex or because it's too expensive, then one doesn't have access to justice. And if we think about these use cases, I do think that there are possibilities where AI could be used to improve access to justice. And also, finally, if you look at the possible use cases, I think there are some that are highly contentious and there are others that are not very exciting. You know, looking at all the information use cases, they are probably not contentious, at least on the party side. So I do assume that no one would really get terribly excited if AI was used to improve database searches. Now, having said all of this, I think it's, again, time for you to have a say. And my third question in the poll. The question is this: as a director of a larger company, or the statement rather, as a director of a larger company, I would systematically integrate AI into the conflict management of the company. So if you had a business and you could either use AI to inform the dispute resolution of your business, disputes concerning consumers, but also suppliers, would you use AI or not? So I've got the results. And here, again, there's a strong majority for doing this. So there's a pro-AI audience, it seems to me. So 29% agree strongly, 52% somewhat agree. And I think probably those who only somewhat agree would have a question concerning the costs of using AI. Because I did not, of course, keeping the question somewhat simple, I did not tell you anything on the costs of using AI. And there are costs associated with AI for sure. So moving on to the hot topics. First, bias. Now, what is the problem here? Where does bias come from? First, there might be bias in the data set. So the data set may have gaps, or the data set may contain mistakes. For example, if we take a data set on court decisions, what if past decisions were wrong? The AI will then learn from that data set and incorporate these wrong decisions. And then there might be bias or discrimination in the data set. There may be, again, taking the example of court cases, what if there's bias in past court decisions? The AI learning from these past decisions will then just predict the future, incorporating this past bias. But it's not just the data set that may be a source of bias. It may also be the algorithm. So what if one uses an algorithm to label certain factors in constructing the data set, for example? What if that labeling goes wrong? Or what if the person constructing the AI chooses the wrong outcome to inform a certain decision? So there are multiple ways in which bias can come into AI and its use in dispute resolution. Now, what can one do about it? I think the first thing to realize is that the solution may be technology itself. And there are some interesting attempts in more recent papers and research to use technology to solve the bias problem. What are such technical solutions? First, one can improve the data set. So one can have more data if one fears that there are gaps in data. Or one can aim to have less biased data. Or one can use algorithm to debias the data. So that is a case where one knows or fears there might be bias in the data, but then uses algorithms to kind of debias the data. In terms of the algorithm, one can also work on the algorithm, solve labeling problems, for example, or perhaps validate an algorithm by applying it to a representative data set and using this approach to find bias. Now, if that is not possible, then the next step might be to bring in the law. And there we can think about rights and obligations. Obligations to avoid bias, or rights for those to be exposed to possible bias, to appeal, to get a human-based decision. The interesting thing here is that we have to distinguish between avoiding negative impact and aiming for optimal solutions. I'm saying this because if we are testing for bias, we are probably looking for someone being negatively impacted by using AI. But if we are taking a step back and we think about what we actually want to achieve, then it is probably getting better predictions, getting optimal outcomes. And these are two different things. So avoiding negative impact does not equal getting the best prediction. And so if we are taking steps using the law to avoid negative impact, we need to take care that we still give AI the chance to achieve optimal outcomes. Another issue to see here is that it is not just AI that is influenced by bias, but there might be bias in existing dispute resolution systems. And AI can be used to detect such bias in existing dispute procedures. You could, for example, provide an AI with a data set of past decisions. And what you then do is you take away, by way of algorithm, one information. For example, you take away information on gender, and then you have the AI predict the outcome. And the interesting thing is then to see if the AI predicts the same outcomes with or without the gender information. So same outcomes, then there's a good chance that there's no gender problem in the past decisions. But if the outcomes are different, then it seems the AI then detects a gender issue. So AI does not only have a bias issue itself, but it can help to detect bias in existing procedures. So it can check for consistency, for example. Then transparency, or the black box problem. I've mentioned this already, and the technical issue, as explained, is that even those operating the AI do not always know what factors the AI really uses to develop its predictions. Now that's the technical problem. Now the ethical problem is that just dispute resolution is based on explanations. So just dispute resolutions, I think it can be argued, is not just a just result, but part of such just dispute resolution or good dispute resolution is also that those affected get an explanation. Now, if AI can't provide such an explanation because the factors are not known, then that element of justice is missing. One thing to realize is, however, that there's a difference between an explanation and factors. Because an explanation is a narrative where someone explains to us why we will be exposed to a certain decision. And that is not just a list of factors that maybe the AI may provide. So even if we would come up with a list of factors that the AI bases its predictions on, that is still not an explanation. On the other hand, we do know that explanations that we get in our daily life are not going on forever. They may cover 1, 2, 3, maybe 10, even 20 pages. But the AI, on the other hand, may come up with factors, say, running into the thousands. And then the issue is, what if the AI uses so many factors that it is not practical to actually provide all of these factors to those affected? Now, in terms of solutions, we may again first look to technical solutions. And there's recent research, for example, using AI to generate explanations. And this approach is used because if we use AI to predict outcomes or to assist in decision making, then also the explanation part ideally should be scalable, because there's no use if the AI just provides the result, but then the explanation needs to be generated by humans. So one thing researchers have worked on is to reach scalability in generating explanations. One way to do this, for example, was to manually first tag certain elements of explanations in existing decisions, and then use that and algorithms to generate new explanations for other cases. A challenge in this is, however, that it requires the AI to match rules and facts, because explanations in law usually will require that those affected receive an explanation on which law is applicable, why it applies here, and this is based on the existing facts. However, as you've seen, the very high prediction accuracies reached in past projects were often based not on the law, but just on the facts. So here the challenge, I think, going forward will be for AI specialists to match rules and facts, and thereby then have the possibility to create explanations. There are also legal solutions that may be requirements for transparency, or what has been used already is that parties agree on algorithms that are used. And finally, a question for you to think about is whether what we're actually aiming for is the type of explanations that human judges, ombudspersons, or arbitrators would provide, or whether whether we should actually aim for something else. Again, the question is what we have already the best we can aim for, or could we use technology to aim for better things? Now to end, the last question to you, and then my final slide. This is the question, and this is perhaps the most contentious question I will ask. Again, it's rather a question formed as a statement, and it is, as a party, I would welcome if the judge deciding my case uses AI to check the judgment after it is made and consider amending the judgment if the AI diverges. Do you strongly agree, somewhat agree, neither agree or not disagree, somewhat disagree, or strongly disagree? So would you prefer, if a court was sitting on your case, that after the judgment is written, the judge uses an AI to check the judgment, and if the AI diverges, would you prefer the judge then to rethink the judgment? Oh, so this is really interesting. So I think we still have a majority that would like to see AI being used, and that is a 65% majority. 24% strongly agree, 41% somewhat agree, but now there are more who disagree. Altogether, 26% of you disagree, and that is 17% somewhat disagree, and 9% strongly disagree. So here I think we see the majority shrinking, so to say, but it's still existing. And it's probably because some people are somewhat at an unease if they think about AI interfering in court decisions. So to end, with some considerations on ethics and the use of AI, and after that, I'm very much looking forward to your questions. My personal opinion is that AI can improve access to justice if we consider that sometimes the law is too complex, too expensive, and AI can help make the law less complex, help us to understand the law, predict what the effects of the law will be, or make it cheaper to apply it. However, I also do think that there are not only advantages, but also risks, and I've dealt with bias and transparency as challenges to the use of AI in dispute resolution. Now, if we use AI in dispute resolution, then I think what will happen is that people will be better in foreseeing the effects of their actions in law, and that will then lead to a state where people rather manage and create legal effects rather than a state that we have today where people first act and then are somewhat exposed after they have acted, surprised by the results or the legal results of their actions. In looking at this, I think that ultimately it is the citizens' interest that should guide lawmakers. And if we start with what is good for people and their dispute resolution, then I think we do have expertise from the past that we can use for the future. Because also in the past, we have faced situations where resources are constrained, where courts do not investigate the truth, but they at some points stop because it's too expensive to find the truth. And where court decisions are made under time constraint, resource constraints, and we have learned to deal with that. But we also have expertise on procedural rights, human rights as a result, and we have learned to deal with the tension between finding the truth and cost efficiency. So I do think that the ultimate tension is not entirely new. It is just a new technology that challenges us here. However, if we do use AI, it is just not enough to just plug it into the existing dispute resolution systems, but I think it will require us to fundamentally rethink our dispute systems. And I do think we are just starting to do so. And that is, we do currently not have the final answers on how to properly use AI in the dispute resolution process if we wanted to do so. I think if we want to use AI going forward, then we need to think very carefully about the ethical issues that are at play. And as a background, I just wanted to tell you that that is something I'm working on together with colleagues here at Cambridge and colleagues in Japan. We have a common ERSRC funded research project. And as part of that project, I'm working on a guide for regulating artificial intelligence in dispute resolution in order to establish where AI may be used, where AI should not be used, and if it is to be used, then how. So thank you very much for your opinion so far, and I will now move on to your questions and answers. In order to do so, I will stop sharing my screen, so I hope you get a better view of me. And I'm very, very grateful for your questions. I already have 42 questions, which probably means I will not be able to answer all questions, but I'll do my best to answer most of them. Starting with the first question, how can AI creators build public faith approval of their algorithms? Will they be used under consent only, or can trust be enough to use without consent? That is a very good question, because I think with all of dispute resolution, whether it uses AI or not, trust is very essential. Trust even of those who do a result that is not in their favor. And we have seen from past research, empirical research, that if there is trust in dispute resolution, then the citizens and businesses will accept the outcome, even if not in their favor. So then how do we build trust in AI? I think one important thing is to explain it, because I think people rather trust applications they understand, but if it is a black box to them, so if people do not understand how things work, they tend not to trust it. And that means attempts by all of those involved, and that includes myself, and I'm trying to do this today, to talk about AI, to explain what it can do, what it cannot do. And I do think that this is an ongoing obligation, because this field is changing so rapidly that that after 2 or 3 years, what I say today will probably be outdated, and so this is an ongoing discussion. I also think that it requires dispute resolution bodies and governments to engage with citizens, and also ask them what they prefer, and also lay open the tensions between, for example, making dispute resolution cheaper, but perhaps more AI-based, or having more expensive dispute resolution and then less AI. Because I think resource constraints are an issue that that governments should discuss, but I think it's rarely discussed. Then there's a question: has your research produced any insights related to the presence of bias within the decision-making process by humans? I have not done such research myself, but I do expect that such research will happen. What I'm currently trying to do is first to engage in research similar to what I've presented today, that is to describe what is currently possible, to lay out the problems. But I certainly think that this is something useful, and I do think that or I would encourage dispute bodies to engage in such research. So now I'm going through the questions. So someone asks, can the case crunch AI advise me what details I should stress in my PPA claim and which items I should remain silent on? That is so the students didn't do this in their project, but you could do it. So what you could do is you could use AI to determine factors that have been relevant in past decisions, and then you could use AI to inform your submissions. There are already service providers, for example, providing advice on the success rates of lawyers for certain courts, and one might use this or not. It's up to the parties to use such services or not. This brings me to, I think, a problem that we will face, and that is, what if one party uses AI and hires the lawyer that has the highest success rate at a certain court, presents the facts and their opinion in a way that is more likely to convince the decision maker, and the other party does not have access to such resources, perhaps because the other party is poorer, or perhaps the matter is not as relevant for the other party, so that it is quite rational not to spend on AI analysis. But what this will create is an imbalance, so that we will have one party equipped with AI information and analysis and the other not. Now, how do we deal with that? We have experience again with dealing with such situations, because we've got experience with unfair terms. So we are used to dealing with the problem that one party imposes standard terms on other parties, and these standard terms will be better informed, will probably shift rights to the party using those standard terms, and the other party, for example, often consumers, not being in a position to impose their standard terms. So what has the legal system done with that? There are laws on standard terms and unfair terms. And so we might need to think about this to perhaps establish balance in decision-making processes. So these are the things that I have in mind when I say that there are opportunities, but there are also challenges, and we have not yet fully thought through how to deal with these challenges, but we will be in a position to do so, I think. So now here's a question. Was research carried out into the 13% that the AI got wrong, to assess how it could have got some of these correct? So I'm choosing that question because I think it is what many people worry about, and I think it raises at least three important issues. Now, the first is the most obvious. I'm asking an AI for advice, and I for example, case crunch, and I'm unlucky, and the advice I get is wrong, because AI only gets it right in 87% of the cases. So in 13% of the cases, it's wrong, and now I get wrong decisions. Sorry, a wrong prediction. To answer the question, that's kind of the first issue, is can you do something about it? Yes, you can do something about it. one way to improve it is to improve the data that the AI is fed. So perhaps you remember the high prediction accuracy of the French research project. One reason why the French research project had such, on the French Supreme Court, had such high prediction accuracy of 96% is because the data that the AI was trained on was more intensely pre-processed than the data in the other cases. So essentially, you're providing higher quality data to the AI. The other thing that happened in that project was that those then entering the case to be predicted got guidance. So the program essentially asked for specific information from those asking for a prediction. Whereas in the other cases, or in the other research projects, the AI was fed more messy data for the case to predict. So if we think about practical uses, it's not out of this world to think that someone asking an AI for a prediction would be guided in terms of what information to offer to the AI. So there's something you can do about it. Now, the second issue I wanted to mention here is that there is an important difference between the parties using AI to predict what the court will do and a decision maker, say a judge, using AI to decide. Because if I'm using AI to get information of what will happen in court as a party, then I will still get we're still imagining a human decision. And so what the AI does is it tries to predict what the human will do, what the human decision maker will do. And I think also in the audience answers, we've seen that you as an audience, you were more comfortable with using that for private information as a party than to start using AI on the court side, on the decision maker side. So it seems there is a difference. And it raises the issue whether justice, in particular court decisions, require human involvement or not. And now the third point. The third point, if you think about a judgment, think about past judgments. Many of them will be right, but there might be some wrong judgments in this. Now, what does AI try to predict? AI does not try to predict the right judgment. AI rather, in those cases I've presented, predicts the judgments that judges or ombudspersons or arbitrators will render. So the AI is not used to create the correct outcome, but it's used to predict the outcome that people will decide on. And so this raises the issue of asking ourselves, what do we require? What should we work towards, both for human decision makers, for AI? Currently, AI research tries to predict human decisions. But I'm not aware of legal AI research trying to predict the right outcome. So I think there's a very interesting field, and I think this. So I use this question to kind of to work out these three issues, which are very, very fundamental and raise difficult ethical problems. So someone asks, you use PPI claims as an example of AI in dispute resolution. Which other areas, sectors would best lend themselves to use of AI in dispute resolution, and why? So that's a very good question, and my answer will show you how fast the field is developing. So if you would have asked me 2 years ago, my answer would have been AI lends itself very well for cases where you've got a big data set. So that means you've got many similar cases, and they are on a simple legal question. So the PPI question, for example, is not terribly complex. On the other hand, if you think back to the to the US Supreme Court case, Katz and others, 2017, these Supreme Court cases are actually not simple technical questions. Actually, what they are rather, they are rather questions of principle, even political questions. And the interesting thing here was that in the Katz paper, 2017, and there's an earlier paper, what they did, they also checked with some legal experts to predict the outcome. And the interesting thing was that actually the AI again was better in the prediction than legal experts as regards Supreme Court decisions. And the speculation is that because Supreme Court decisions are not technical outcomes, but questions of principle, legal knowledge then was of less use to the legal experts because their competence is in legal technical knowledge, whereas the AI was better in actually gathering the principle issue, also kind of predicting how individual judges would decide, because the AI could digest all the decisions of those judges in the past. And so the AI, interestingly, was also good in predicting principle. Now, that would have been my answer 2 or 3 years ago. Now, in the meantime, there are new developments where we see AI being used on smaller data sets with interesting and good results. And so I think this is very much ongoing research where what I say today may be wrong tomorrow. I think it reminds us that AI and dispute resolution is not something that where the strength of and weakness of technology is fixed as of today, but it's really an ongoing issue. I think this brings us to the end of my presentation. I'm very grateful for your questions and for your participation during the course of this presentation. And I'm also very sorry for the very good answers. Very good questions that I also see. And please understand that I cannot answer all questions. You probably have spent your lunch break on this session, and I think you probably have to go other places now. It is 1:30, and that's why I would like to thank you again. Thank you for joining this session. I hope you got something out of it. I enjoyed it very much. Thank you for your questions and comments by way of answering the polls. And I wish you a very good afternoon, and I'll now hand back to the organizers. Thank you.